How to answer a problem question in equity and trust. First of all, you should consider that the key topics to revise for equity and trust exam are the following: 3 certainties and formalities, charitable trusts, non-charitable trusts or purpose trusts, fiduciary duties and gifts. Those are the topics that usually come up in equity and trust exams, so make sure you're familiar with them. Use the IRAC structure for answering problem questions. Everyone knows that it has to be the IRAC structure, but it is often overlooked or not applied correctly. You need to practice this beforehand. So make sure that you draft as many answers as possible from past exam papers on equity and trusts using the IRAC structure. So once you turn up on the exam, you know exactly what is expected from you and how to answer a first class how to write a first class answer to your equity and trust problem questions. You start with issue. What is the issue in the given scenario? Rule. Identify the relevant law for the problem question that is given to you. Then apply it to the facts of the case. You need to apply the law to the facts. And finally, you have to make like mini conclusions after each legal issue. Please remember that your goal should be to identify and correctly analyze at least 80% of all the legal issues that arises on the problem question. It's practically impossible most of the times to do 100% of it. That's why nobody gets 100% on law exams. It's usually 80 is usually the highest you can get. But as long as you can get 70, it's already an amazing grade. So your objective should be to get at least a 70, which is a first class. Today we will revise gifts and we will practice answering a problem question about it. When 3 certainties are not met, trust fails. As you know, there are 3 certainties for a trust: certainty of intention, certainty of object, and certainty of subject matter. If any of these 3 certainties are not met, trust fails. There are alternative ways of enforcing a trust. For example, there are exceptions like charitable trust. For a charitable trust, if there is no certainty of objects, that's fine. It can be a charitable trust or purpose trust, but those are exceptions. Normally, if any of the 3 certainties fail, trust fails. An alternative way of enforcing a failed trust is a gift. The main rule is that claimant cannot rely on the law of trust to complete an imperfect gift. This was the main rule, orthodox principle established in the case of Milroy versus Lord. So technically, we cannot do that. We cannot enforce a failed gift by using a trust. Reframe. Equity will not complete an imperfect gift. That's another case about this. Difference between a trust and a gift. Trust is a transfer of a legal title, but the equitable title still stays on the original owner. So what is a trust? Trust is when a legal title is transferred from one person to another, but equitable title still stays with the previous owner, the previous trustee. Gift involves an intention to effect a transfer of absolute title in property from the owner to another person. So basically, the difference between the trust and gift is that equitable ownership still stays with the previous owner in case of a trust, whereas for gift, it's absolute transfer of both legal and equitable ownership. Relaxation of the rule. We have seen in the case such as Rose that this orthodox principle that comes from Milroy versus Lord has been relaxed. It has they argued in the case of Rose that if the donor did everything in his power to complete the gift but died before the gift is complete, then equity can be relied upon to complete an imperfect gift. In this case, the husband wanted to gift his shares in a company to a wife, but he died before the formalities to register the title was complete. But what he had to do, all the steps he had to follow, the paperwork and all the other formalities, he did that. But it was the matter of completion of registration, which he had no control over. So because he did everything in his power to make this gift, the court enforced it. Problem question. Peter invited his stepdaughter, Emily, to live with him in his house to take care of him when he was ill. He promised that he would give her his house as a gift in exchange for her taking care of him in his time of need. Emily agreed, gave up on her career, and moved in with Peter to take care of him full time. However, Peter did not follow the formalities to complete the gift before he died. According to the intestacy rules, the property should have passed to the deceased person's brother. Would Emily be able to receive the property as a gift? First issue that you should discuss was if Emily can establish that the property was a gift for her, was an effective gift. The rule is you have to explain the relevant cases, like Milroy versus Lord is the starting point, is the orthodox principle. As per Milroy versus Lord, if the formalities were incomplete or not done, a gift would be invalid. By applying this strict rule, Emily cannot get the house as a gift because it's a strict rule, no formalities, then no property can be passed to Emily. But there are exceptions. As you know, in English law, there is never a yes or no answer. Mostly every rule has an exception, like this one. The strict rule of gifts was relaxed in the case of re-rose, which could apply here. So you have to apply the second case, re-rose, which shows an alternative interpretation of this rule. As per re-rose, the gift takes place at the time the transferor completes all the formalities which he himself could have done, as opposed to when all the formalities in general were satisfied. So the matter here is, has the donor done anything at all to complete this gift? The answer is no, because according to the problem question facts, the donor has not done anything to complete the gift. So re-rose principle cannot save Emily. We have to look at other things, other legal principles that potentially could grant ownership of the property to Emily. Other more relevant cases to elaborate the arguments before could be Masco versus Masco. The transfer in this case was not registered, but the settlor did everything he could have done to transfer the property to his son. Therefore, the gift was complete. But in this case, as we argued already, Emily cannot get the property because the donor has not followed the relevant formalities, the relevant steps to transfer the absolute ownership of the property from himself to Emily. The next legal issue would be to discuss if any alternative route exists that Emily could rely upon to get the property, despite not being able to establish a gift. This alternative route would be proprietary estoppel. This is an equitable principle that can, in some circumstances, remedy a failed gift. Requirements for establishing a proprietary estoppel are the following. First, promise or representation by the defendant that the claimant will acquire some rights in the property. Second, claimant's reasonable reliance on this promise. And finally, detriment. So briefly, promise, reliance, and detriment. These three things must be shown. Now we have to apply this fact to the facts of the case. In this case, Peter promised Emily she would get the house. So this requirement, the first one, the promise representation requirement, is satisfied because there is a clear promise. Second is reasonable reliance. Grizzly versus Cook. If clear assurances have been made and detriment has been suffered, it can be assumed that reliance has occurred. This requirement should be satisfied in this case of Peter and Emily, because in relation to reasonableness, objective standard applies with burden of proof on the defendant. Defendant should be the nephew of Peter, who should be claiming the property, and he should be proving if it was not reasonable for Emily to rely on Peter's promise. So according to the intestacy rules, I believe it was the nephew of Peter who was going to get the property. So he would be the claimant because Peter has passed away, and he would be the defendant, and Emily would be bringing an action against the nephew. It is unlikely for unreasonableness argument to succeed because it seems that Emily was clearly promised the property in exchange of her taking care of Peter when he was sick. So there was reliance, the promise was clear. Peter clearly promised to Emily that if she took care of him, she would get the property. And Emily relied on that promise based on the facts. There's no doubt about that. And finally, the detriment must be shown. So the detriment is basically, has the claimant been worse off as a result of having relied on the defendant's assurance? What she did here was she gave up on her career, and that's a detriment. There must be an explicit link between the representation and the detriment suffered. Would she given up her career had Peter not promised the property? Probably not. So you should make that kind of analysis to show that the detriment is in relation to the promise. As long as the detriment is neither minimal nor trivial, no specific form is required. It cannot be trivial, so it cannot be minimal, but I believe that giving up a career can be more than minimal, can be more than trivial in this case. So most likely detriment requirement is satisfied. At the end, you can have a very brief conclusion. Problem questions do not require elaborate conclusions like essay questions, just a very brief conclusion. You can argue that Emily will most likely not be able to establish the ownership of the property by relying on gifts because the formalities have not been followed by application of the cases such as Milroy and Reed Rose. However, proprietary estoppel can be relied upon, and if proprietary estoppel is successfully established, there are high chances of that, then Emily can get the property. Now I'd like to tell you a little bit about what simple studying does and how we can help you get high grades on your exams in equity or in any other legal study modules. Our recommendation is to start studying by our materials. So instead of like big complicated textbooks, you can use our materials, which can save you hundreds of hours of reading and focus your attention to what is important, what you need to know on the exam, very practical notes. And this, for best result, study materials should be used in combination with our tutoring service, because that's one-to-one tutoring and personalized support to help you understand how to answer problem and essay questions. And finally, attend the free revision sessions like this one. If you subscribe to our YouTube channel, we have all the revision sessions there that we have delivered so far. So please subscribe to our YouTube channel, and for free, you can see all our revision sessions. We have already 25,000 subscribers on Simple Studying and from UK law schools. So you should join Simple Studying as soon as possible to join our growing community. Most of our users get very high grades when they study with our premium membership in combination with our tutoring sessions. In fact, 90% of our regular users have reported to have got a first class after getting at least 6 hours of tutoring and studying regularly with our study materials. So my recommendation would be to start studying with our materials and start tutoring as soon as possible. Thank you very much for your attention.